not going to do a big introduction for Marcia Waters because that is not necessary. Everybody knows who you are. Everybody is super excited to have you on today, Marcia. We always love to hear what you have to say and how you like to say it. So, and of course, Mr. Damian, appreciate your time as well and your input. And with that, Marcia, if you would like to take things away.
So I think the last time I did one of these was probably about a year ago, and we're still dealing with COVID. Just at a different level, at least as far as we're concerned, because really enforcement of COVID violations at this point has transitioned from the state level down to the local municipalities and counties. The mask order was updated on May 2nd. I'm not going to go into that into too much detail because I will tell you that your guys' efforts to be compliant with COVID have gotten more difficult rather than easier over the span of the past year. So you need to be extremely aware of what is going on in your local counties because there is a lot of variation as far as what is required. Statewide, the mask order is required basically for all public-facing state government facilities. It's required in schools. But then when you start looking at incidence rates among the counties, depending on what the incidence rates are, you may or may not have to wear a mask in a public place. It also depends on vaccination rates. So definitely make sure that you are keeping yourself up to date on what's going on at the county level, because that's going to be governing your activities. I will tell you that starting June 1st, government buildings, the governor wants our government buildings to be open to the public. So what that's going to mean for Dora is the Welcome Center will be open. It's going to be on restricted hours. What they've been discussing is that it will be open from 9 to 1. And with the Welcome Center, there's 3 basic divisions that man the Welcome Center. It's the Division of Professions and Occupations, Division of Insurance, and Division of Real Estate. So Profession and Occupations is the largest division in Dora. They're going to have somebody in there 2 days a week. Division of Insurance will have somebody in there. Real Estate will have somebody in there 1 day a week. So the way that they're going to do it is not only are the hours going to be restricted, but it's going to be by appointment only. They're going to use some sort of online appointment scheduling tool in order to facilitate that. But if you have an appointment and you come down to see us, you have to wear a mask. They will have protective gear available if you don't have it. Just make sure that you've got an appointment, because drop-ins, that's not something that they're going to accommodate. And I believe they were tentatively talking about Wednesday would be Real Estate's Day, but I haven't seen anything set in stone yet. So you will have in-person services. I think for the most part, people have done a really good job about dealing with online over the past year. And if you still have that ability, I would suggest doing that rather than driving down to Denver, particularly if you didn't schedule an appointment. Some of the other things that you guys are having to deal with, I guess there's an issue now with people forging vaccination certificates. So for those of you that live in a county where you don't have the incidence rates that require wearing a mask in public, I don't see the commission saying that you have to be responsible in being able to identify a vaccination certificate that is real versus forged. They don't do that in any other aspect that you deal with in real estate. I would say you may want to just err on the side of caution because there is so much disparity, and you may just want to continue to wear masks during open houses and showing appointments. Definitely keep in mind that people are using video doorbells a lot these days, and a lot of the COVID complaints that we got over the past year had to do with Ring doorbells. So keep that in mind. People are still watching your activities while you're in their house. And also, sellers can impose more restrictive requirements as far as showings and open houses are concerned than the counties are requiring. So if the seller tells you everybody's got to wear a mask, your duty as the listing agent is to make sure that people are complying with that. I think that's all I pretty much have as far as COVID is concerned. So I thought I would go over the common complaints that we've been seeing. And then I'm going to go over the advertising rule. Some of the common complaints will kind of bleed into the advertising rule discussion. But there were a few things that have come up over the past year that really do not fall within our jurisdiction. And I actually did a newsletter article on some of those because we keep seeing complaints. And it does take some time to file a complaint online with us. And if you're filing complaints with us that we don't have any jurisdiction over, it's just a waste of your time because we're going to dismiss them in intake and we're not going to look at them further. So the first one I wanted to go over is the clear cooperation requirements of the MLSs. We don't have anything on the commission's books that requires you to enter a property into the MLS within 3 days. What we're going to look at is, did you agree to put a property in the MLS as part of your advertising and your listing agreement with the seller? Did you or did you not put it in the MLS? Was there a delay in putting it in the MLS? And was that delay addressed with the seller? And if none of those things happened, then that could be an issue as far as unworthy and incompetent behavior in front of the real estate commission. But we do not enforce clear cooperation. So the 3-day rule, that is not something to raise with the real estate commission. If you're seeing those issues, that's something that you need to bring up with the MLS itself. The other thing that's been happening in the market, and this to some extent does fall in our jurisdiction, although I think people are enforcing it on their own rather than having the real estate commission enforce it, has to do with geographic competency. So we've been hearing a lot of complaints about brokers excluding other brokers from practicing in certain markets because the brokers in those markets are saying, well, you know what, this is Vail and you're coming from Boulder, you don't have geographic competency. And that's really not for the market participants to decide. That's for the real estate commission to decide. Just because somebody's coming from Boulder and they're going to sell property in Vail doesn't right off the bat mean that they are not competent to do so. They may have done their research. They may have gotten access to the property databases. They may have taken the steps to become competent to sell property in that market area. So just keep in mind, you as a real estate broker, you're not the one that has the authority to deem somebody to be geographically incompetent. And you also have to be really careful about excluding other market participants from practicing in certain areas, because while it may or may not fall within the commission's jurisdiction, when we start to see behaviors that also look like they may bleed over into other jurisdictions, and in this case, potentially federal law, as far as Sherman antitrust and restriction of trade, not only are we going to address it, but we will refer it on to those other agencies where we think it falls within their jurisdiction. And frankly, I don't think I would want to have to go in front of the Federal Trade Commission or the Department of Justice on a restriction of trade complaint. What you get at the commission level, I think a lot of people, it's hard to write some of those fine checks that the commission levies, but it's nothing compared to what the federal government can do to you when you violate one of their regulations. So be careful with that as well. We've also been hearing a lot about commission disputes. And I know that the Land Title Association has put together an informational piece that they asked us to send out, and hopefully we'll be doing that soon. It's really not the title company's job to settle a commission dispute between two brokers. We also don't do commission disputes unless it is the result of a sign crossing where a consumer is on the hook for paying two commissions to one broker or two brokers for basically representing one side of the transaction. That's when the real estate commission is going to look at the sign crossing aspect. But your commission disputes, whether it's a payment issue between you and your employing broker, you and a cooperating broker, that is not something that we address. So it's a waste of your time to file those complaints with us. The other thing that came about this year is a change in the ethical requirements with the Association of Realtors. And basically, it can be an ethics violation depending on what your activities are, not only within the boundaries of practicing real estate, but also in your personal lives, as far as how you deal with other ethnicities, countries of origin, just basically people in general. Ethics violations are restricted to the Association of Realtors. So when somebody says that, they file a complaint with us and say, well, this is unethical behavior, we're going to look and see, because we don't regulate ethics, we're going to look and see if the behaviors fall into unworthiness and incompetency, or if there's an aspect of dishonest dealing. The Real Estate Commission does not regulate your viewpoints outside of real estate transactions. So as long as you're complying with fair housing and the other applicable state and federal laws, your personal beliefs, there's no jurisdiction for the commission. So um, we've seen quite a few complaints come in about, political posts that people make on social media. We don't regulate that. You've got a First Amendment right that allows you the freedom of speech and expression. We have to balance your First Amendment rights with what state statute says as far as your real estate practices. So basically, the sum of this is we do not enforce the ethics rules that the Association of Realtors have adopted. And then the other thing that we've been seeing a lot of, and I go over this regularly when I do speaking engagements to the brokers, is I tell you guys that throughout the year, anytime you're going to sit down across the table, the closing table from another broker, you should be checking to see what their license status is with us on the e-license system, because for them to be sitting across the closing table with you, they need to have an active license. So recently what we've been seeing is we've gotten a lot of complaints in where it's like, well, Marcia doesn't have an active license. Okay, so just having an inactive license isn't a violation of the license law. If you're going to report somebody for doing unlicensed activity, which that's, if you've got an inactive broker that is doing licensed duties, that's unlicensed activity. We're going to need some more information about what's the transaction, where's the property. We need specifics. You can't just put a generic one sentence liner into the complaint saying Marcia doesn't have an active license, because we have nothing to go on. And a lot of those complaints are filed anonymously, so we can't even follow up with the complainant. So while we want to deal with unlicensed activity, you're going to have to give us a little more information than what you have been supplying us if you have been filing those complaints. So that leads me into kind of the discussion of the advertising rule and some of the
Marcia,
reasons.
before you go too far into the advertising, we had a couple questions that came in. Would you mind maybe take a breath for just a second? Yeah. And then we'll ask, and two of them are pretty much the same, and the question is about, and frankly, I'm not sure that you're the right person to ask on any of these, but they say, okay, we get that we have to wear masks, but the question is about gloves. Everybody hates gloves. They do not want to wear gloves. They think gloves are stupid. I'm paraphrasing. Obviously, they didn't put that in the question answer. In fact, they ask these questions anonymously, I'm sure, because they don't want you to know who it is. But do you have any feelings on gloves as far as, I don't think that's your jurisdiction anymore, is it?
It's not, and I'm not aware of any requirements at this point that you have to wear gloves. It's focused more on the masks.
Okay. And I think it would be at a county level, I guess, if there was glove requirements, but it seems like they've gone away from gloves, so.
I would trade gloves for a mask, but
well, that's because you want to go to the gym.
Yeah, and it's not fun when your glasses fog up and you can't see what you're doing.
Can't read your heart rate.
You want to go ahead, honey, and ask the next one? I don't know as this is her jurisdiction either, but.
Sure. Okay. So this individual has heard of credible evidence suggesting that Home Builders Association members have been colluding on co-op agent commission rates. It seems that they have with agreement amongst themselves to offer the same rate, which happens to be substantially lower than the historical rate. Regardless, isn't this type of discussion, wouldn't this be in violation of antitrust laws? And also wondering if you've heard of this practice recently.
Well, so I haven't recently heard of any collusion, and we don't enforce Sherman antitrust, but if you're price fixing, I definitely think that is something that would be a concern. And I would encourage you to file a complaint with the Federal Trade Commission, because they enforce Sherman antitrust.
Okay. And another question that came in, which if we're fully vaccinated, do you still need to wear a mask, or is that up to our county? I'll take this one just quickly. Guys, if you're fully vaccinated, it changes the whole mask mandate requirement. But my suggestion, I think, was what Marcia said too, is everybody's watching you. So just wear the stupid masks when you're doing the showings in the open houses, so that people don't turn you in for stuff that may or may not be violations, because nobody knows if you're vaccinated or not. It's not like you have a a stamp on your forehead that says vaccinated, even though I was tempted to get one. So, just, err on the side of caution. But Marcia, you have anything to add?
Well, and I think it also speaks to whatever your county incidence rates are, because that seems to be the big determinant as well. If your county is in the higher incidence rates, I don't think it necessarily matters so much whether you're vaccinated. It's like the size of the crowd you're dealing with, how many other people are vaccinated. It's definitely not easy to distinguish when you get to take that mask off.
Okay, so I think we're done with that. And it's time to move on to advertising. Isn't this exciting?
So I'm bringing up advertising just because if we could ban everybody's use of social media at this point, I would be all for it. Social media has not brought out the best in people, particularly over the last year. And we've been getting a lot of advertising complaints attached to social media. The advertising rule doesn't apply just to social media, but I wanted to go through the different elements of the advertising rule because we do get a variety of advertising complaints. They're not confined to just social media, but I think in general, it seems like we see an uptick in advertising complaints in spring. It's kind of when the market starts picking up. And when you've got a limited inventory, I think you have a lot of licensees that are paying a lot of attention to what other people are doing. And it's mainly other brokers that are complaining about advertising violations. So first off, you can only advertise in your license name that you have licensed with the commission. You can have a nickname with the commission, but you have to register it with us. So I'm licensed with the commission as Marcia Waters. I don't get to go out and plop down yard signs advertising my listings for sale as Skippy Johnson. That's not a name associated with the real estate commission. So, and a lot of what we see is, brokers will just use their first name unless you've got that registered with us as your nickname. You don't get to do that. It's got to be the license name.
Can I call you Skippy from now on?
I picked a name that is nowhere near my personality type. So go ahead and call me Skippy, Damian, and I will come up with a special name for you too. So the next thing, and this is raised quite a bit, is when you're advertising, you have to advertise in the name of your licensed brokerage. The only exception to that is when you are selling property of your own and it's not being listed with your licensed brokerage. So we need to see the license name of the brokerage or the trade name, because a lot of brokerages have trade names, but that's what you need to make sure that you're advertising it. And we get a lot of website complaints where, Marcia's set up her own website and there is no mention of the brokerage that Marcia works for. So you need to make sure that on every viewable page, your license name and that brokerage license name appears. Brokerage firms can only have one trade name. So keep that in mind. You don't get to have 15 different trade names for one brokerage. It is one trade name. They may have different trademarks, and those have to be individually approved by the real estate commission. And you can see a lot of disparity. There's certain brokerages that they use a bunch of different trademarks or logos. That's fine as long as they've gotten approval from the real estate commission before they start using them. So another thing that we see quite a bit is brokers that are advertising professional designations. Like if I'm going to say Marcia Waters ABR, well, I better be in good standing as an ABR to advertise that. We also have a lot of brokers that will do advertisements that say, Marcia is the best real estate broker in Colorado. And when we see those advertisements, we start asking, okay, who gave you that award? You basically have to put your money where your mouth is. And it's not just upon commission request, it's also if the public asks to see who gave you that award. So be careful when you start proclaiming to be the best at anything, because you are going to have to show proof as to how or why you are the best at that. Teams are something that I think is the bane of the existence of many real estate regulators, because there's several issues associated with teams. It's not just with advertising, it's also with operation. We kind of try to address both within Commission Rule 610. So a team is 2 or more brokers. If I am one broker, I cannot advertise as a team. You're just going to be advertising in the name of what you're licensed under with the Real Estate Commission. When you have 2 or more brokers, though, and they're going to advertise as a team, there's certain words that they can't use, such as realty, real estate, realtors, company, LLC. You can't use any sort of terminology that's going to lead a consumer to think that you are an independent brokerage in and of yourselves. And so along with the other issues that we see with teams, because a lot of the time they operate like they are their own little independent broker, that is why they are restricted to a team can only operate within one real estate brokerage. And we did that for supervision reasons. We're not going to allow teams to operate across brokerages. So you will never, if in compliance with this regulation, you will never see a real estate broker from like RE/MAX team up and be a team with somebody from Coldwell Banker. They don't get to do that. And we have not allowed that because when there's supervision issues, we do not want finger pointing among the employing brokers as far as who was responsible for the supervision of their activities. So it's confined to one licensed brokerage. The advertising rule also requires that all advertising that you do has to be accurate, and it has to comply with copyright laws and other applicable laws and regulations. So a lot of the advertising complaints that we've been getting lately allege that, well, Betty Broker has stolen my pictures and she's using them in her advertisements. Okay, so that allegation alone, that's not something that we're necessarily going to open up a complaint on. It's when the allegation is Betty Broker is using my photographs and those were copyrighted and she's using them in her advertisements. That copyright aspect is going to trigger the investigation getting opened up. So you really shouldn't be using other people's data for your advertising, but the copyrights in general, that'll catapult you into the Real Estate Commission's world. So be careful as far as what you're using. Then there's electronic media, and this bleeds into my favorite topic of social media. So on your websites, every viewable page, it's got to have either the licensed broker or the team's name on it, and it's got to have the brokerage firm's name on it. Every viewable page. When you're dealing with expired listings and you maintain your own website, you've got to remove those expired listings within 3 days. If somebody else is maintaining your electronic media, you have 3 days within the expiration of that listing to request that they update your data page. Anytime you are communicating for purposes of advertising through email, chat, instant messages, blogs, whatever it may be, you have to use your licensed broker's name, or if you're a member of the team's name, and it also has to have the brokerage firm's name on it. Now, there's a distinction between that's when it's used for advertising versus when you're communicating with your client. If you're giving them updates about, hey, the inspection is scheduled for this date, you don't have the same requirement. You're not advertising at that point. You're keeping your client up just apprised. So there is a distinction there. The other thing that we get a lot of complaints about, and this particularly has to deal with social media, is we'll get a complaint that, hey, Betty Broker is advertising my listing on her Facebook page. So there is a specific provision in the advertising rule that addresses this, and it has to do with authority to advertise. One real estate broker cannot advertise the availability or the purchase price of a property, whether it's for sale or lease, unless they have the permission of the owner or the owner's broker. So for me to just start advertising somebody else's listings on my social media, unless I have permission, that's in violation of the advertising rule. And you also, if you're going to advertise somebody else's listings on your social media and you've gotten their permission, you also have to disclose the owner's brokerage firm's name. Prices quoted in advertising can only be the price agreed upon by the broker and the owner. We don't get too many complaints about that generally. And then There's also a distinction between authority to advertise, which I just went over, and then basic sales data. So if you're farming a neighborhood and you're going to send out postcards just recapping sales data, you can do that. You need to cite the source of the data, and you also needed to include a disclaimer, if this is accurate, that all the reported sales were not necessarily listed or sold by you, and they're only intended to show trends in the area. Now, if you were the one that sold all of the houses in the area and that's what you're advertising, you don't have to make that disclaimer because you were the broker that either listed or sold those. But there is a distinction. You don't have to have the owner's permission at that point to recap sales data, because those are also not active listings necessarily, and you're just kind of giving a general overview of the market. So that is the advertising rule. Are there any questions associated with that?
There is one here, Marcia, that I think is interesting. It's so it talks about, so what if somebody's licensed in 2 states, and so they're licensed, let's say in Wyoming and Colorado. Do they need to have the name of both their logos and brokerage names on all emails and advertising? And I guess it's, well, I mean, what do you think of that? How's that?
So we're going to look at only the Colorado aspect. So what they advertise here in Colorado has to have their license name here and the license brokerage here. I don't know what Wyoming's advertising requirements are, but if they're if they're dual licensed, you're going to have to comply with the Colorado requirement for the Colorado part, and then whatever Wyoming requires.
So if Wyoming requires it, then you'd have to have both.
Yeah. Or you could err on the side of caution and put, the Wyoming brokerage and the Colorado brokerage.
Okay.
There's a question here about going back to the nicknames. So how does one register a nickname? I have a birth name that is close to my nickname, but I prefer to be careful.
So I think you can go ahead and update that in the licensing system. I haven't tried to do that before though. And if you have a nickname that you want registered, shoot me an email and I will put you in contact with somebody in our licensing section and they can help you do that. I would err on the side of caution with those of you that have names that, like my daughter's Catherine, she could go by Kate, Katie, Kathy. Common sense would dictate that those are all derivatives of Catherine. But I have seen sometimes when it goes over to enforcement that common sense is not necessarily applied sometimes. Like we had a broker that was using Shelley. Her legal name is Michelle. I think you can figure that out, but she got dinged for using Shelley and not having it registered with us. So I would err on the side of caution and go ahead and register whatever nickname you're using. Some nicknames are not even remotely close to the legal name. Like we'll have a lot of brokers that come from different countries, but they will pick an Americanized nickname. And I don't think, kind of on face value, you would automatically like connect, okay, Ben is the nickname, but his legal name is Siddhartha. So it gets a little confusing.
There was another one here that I think is worth addressing. So you talked about teams, how they couldn't be in 2 different brokerage firms, but then this question is, what about listing agent and co-listing agent? And I obviously those agents in 2 different companies, but I expect that's different. So
yeah, so you can co-list a property, but you can't be a team if you're not in the same brokerage.
And then, okay, it looks like we may have wrapped up all the, I wanted to ask a question on advertising too, because, well, I like to make your life miserable, Skippy. So postcards, I've seen a lot of action around people sending out postcards. Sometimes they're sending out postcards because a property sold in the neighborhood. Other times they're sending out postcards that are just listed. And I know a lot of the rules you talked about social media, because that's where a lot of the action is, but can we talk about that a little bit? Because I'm seeing some action in that too.
So the postcards that go out of, hey, look what recently sold in your neighborhood, and it's one specific property. you're now dealing with a closed transaction. The advertising rule talks about basically an active listing that has not closed. So I don't think that the postcards in that example fall within 610.
As far as
I think
needing
that's-
permission.
Yeah, I think at that point, you're then going into kind of the general sales data.
Okay. And then what if it's an active listing? Does that fall under the rule of getting permission?
So an active listing, you're going to have to get the permission of either the owner or the owner's broker. And you're going to have that language on that postcard about who the brokerage firm is that actually has the listing.
Okay. Perfect.
A couple of questions that came up in chat. So one, dual licensing. Can a broker have a license with one brokerage in one and a different brokerage in another state? So you're with Remax in one state and Coldwell Banker in another state.
We don't have any prohibitions against that.
Okay.
The companies might. I mean, you may have company policies that you've got to deal with where they won't allow you to be licensed with additional brokerages.
On signs in the yard, are we required to put pending under contract on the signs as the process goes?
So we are not the sign writer police.
Are you sure?
Unfortunately, yes. I actually saw a discussion come up again amongst the real estate regulators over the coming soon sign writers, and I am so glad that we do not regulate sign writers. Obviously, if you're advertising something and it's contrary to the status that it actually is, that could be seen as a misrepresentation potentially, and that could get you into trouble with the real estate commission, but we don't have any requirement about you guys using sign writers.
And is that it, Willie? Did you?
There were a couple other questions in Q&A. Do you think we should go ahead and address?
Yeah,
those?
go ahead. I mean, I think Marcia will answer the questions, and then
Okay.
the one about TCs I was going to save for last because I'm sure she'll love to talk about commission position 20. But
should we wait on that one?
yeah, let's wait on that one. But I think there's a couple others.
Okay. So can a company advertise an active listing that is for sale on their site for rent?
Andrea, I'm not sure what that question
Yeah,
means.
advertise an active listing that is for sale on their site for rent.
So if they've got an agreement to lease that property, then they can advertise it. But if say like I listed my house tomorrow with Damian, if he was a real estate broker and it's
That'd
for
be
sale,
a terrible idea.
I'm sure I would quickly regret it. But if it's for sale and then somebody posted on Craigslist as a rental, no, you don't have the authority to advertise that property for rent. The seller hasn't even entered into an agreement for exclusive right to lease. So yeah, that would get you into hot water with the real estate commission. And we do get a lot of complaints about that, where it's primarily with Craigslist, where brokers will find that, wait a minute, my listing is being advertised for lease. And these are particularly predatory complaints because this is a bait and switch scheme where they're taking an actual listed property that's up for sale. And typically, these are the ones where it's like, okay, this is for rent, send $1,000 deposit in, and we'll send you the keys. And you have a consumer that unfortunately sends the $1,000 in, they never get the keys, and that property was never available for rent. So I would not be searching for property off of Craigslist based on the complaints that we see.
Yeah, and I wonder if this is one that if you have it listed, if you can also list it as for rent. And obviously, this company is saying they do it all the time, which I told them they can't. I guess he said they are buying it to provide a tenant. Oh, okay. So I guess what's happening is you have somebody that's entering into a contract to buy the property and then putting it up as for lease before they've closed on the transaction.
So I would expect at that point, if that's the situation, there's got to be some disclosure about, the leasing of that property is contingent on the successful closing of the sale.
Right. Okay. You ready for hope we got one more. Oh, wait, this is. I
will tell you about an advertising complaint that we got yesterday that was a complaint about This broker shared my post off of Facebook, and I want him disciplined for it. So the post, I'm not exactly sure where this person even got the picture, but it was a picture of a bathroom that had 2 toilets next to each other. I don't know who came up with this idea, but there was some discussion about, hey, are you comfortable in your relationship to want to have 2 toilets next to each other in a bathroom? The broker who originally posted this on their Facebook was upset because another broker shared that post as their own, and we do not regulate that. I don't know where they got the picture of the 2 toilets. I don't really care. It's not within the commission's jurisdiction. Unless it's an actively listed property and it has to do with, advertising the property for sale, the purchase price. We don't deal with that type of social media issue.
All right. Are you ready to talk about commission position 20? Because the question is your opinion on, go ahead, Jill. I don't have it up. I'm typing a response to somebody else's question. So do you have that?
What are your suggestions on using a licensed TC versus a non-licensed TC?
Well, yeah. My suggestions are the whole reason we revised the position statement, but you've got to be really careful as far as if they're providing license duties, they need to be part of that listing agreement. Regardless of whether they're licensed or unlicensed, there's a supervision component that the employing brokers are going to have to step up their game with. But definitely with the license coordinators, I think the big pitfall has to do with compliance with brokerage relationships. And if they're performing license duties, they need to be a part of that listing agreement.
Yeah, and the whole position statement was just redone just to kind of talk about the different ins and outs of what they can and can't do, whether they're licensed or not licensed. To me, the biggest issue with transaction coordinators is they got to decide, are they acting as licensed brokers in the transaction, or are they not acting as licensed brokers in the transaction? Their license status is somewhat irrelevant. They could have a license, but that doesn't mean they have to act as a licensee. And that's really a lot of the position statement dealing with, which box are you putting yourself in if you're dealing with TCs? So, or reapers, as they've now become known as, thanks to the terminology of the commission position statement.
So I think as a broker, if you're going to engage a transaction coordinator, you need to clearly delineate what duties they're going to be performing so that there is no confusion.
Yeah, and if they're not in your brokerage firm and they're doing license activities, then that's co-listing. That's not just simply adding their name to your listing contract and saying they get information. That's two transaction files for 2 different brokerage firms.
There was a question going back here on does the MLS IDX agreement allow us to advertise on social media, etc.?
So I'm not familiar with that, and that is outside of our purview, definitely. So that is a question to bring up with RE Colorado and see what their response is.
Here's another one. Do we still need to have buyers and sellers sign the COVID-19 advisory forms? Verbiage still reads that we should wear gloves when showing homes. Everybody hates gloves, Marcia, except you, apparently.
Well, it was never a mandatory form in the first place. This was an industry-created document, so it wasn't mandatory. And if you don't want to use it, you don't have to, as far as the real estate commission is concerned.
And apparently you don't have to wear gloves either. So, okay. I have one other question. It's on misleading advertising. It was about lenders. You more obviously deal with MLOs as well, but the question was about no upfront fees charged and implying that a lot of lenders charge upfront fees. Is that something you guys would ever deal with?
We do on the mortgage loan originator side. That and the rates that they're advertising, those have to be accurate as of the day that they're advertising it.
Right. Yeah, you guys have to regulate those guys too. So
yes,
I'm sure you deal with a lot of that program as well. Well, I don't think we have much more in the way of questions, Marcia. How's that for getting you out of here early and easy?
Works for me.
Any other questions out there? We'll give it another second here.
Oh, apparently you can change your name online and it's $25 according to one of the participants. So
Okay. Maybe I'll circle back with licensing about the $25 charge. It's one that typically the charge applies to going from active to inactive. I'll double check with our licensing section about just merely updating your name.
well, hopefully they didn't just change to inactive by accident trying to update their name.
Yeah, hopefully not.
All right, Jill.
All right. Well, I think that's it. Thank you so much, everybody, for joining us. Again, we really appreciate your support of these updates. We hope you get a lot out of them. Please think of me or your Heritage Title sales rep if you have an upcoming deal. We'd love to work with you. And we will see you next month for our next industry update. Have a great rest of your week, and we will see you soon.
Thanks, Marcia.
Thank you so much, Marcia. You are fabulous, as always.
Thank you. Take care.
Bye.
Bye.